No matter how careful one is, data leakage through cyber attacks seems inevitable. Human-based errors can often compromise sensitive data. In Hong Kong, the Personal Data Privacy Ordinance requires data users to take all practicable steps to prevent unauthorized or accidental access of personal data. Unfortunately, there is currently no statutory requirement for data users to notify the Office of the Privacy Commissioner or the affected data subject in case of a data breach. At present, relevant notification is made on a voluntary basis. That said, the Privacy Commissioner strongly advised data users to submit data breach notification to the Office as a recommended practice for proper handling of such kind of incident. You may have heard of European Union's General Data Protection Regulation, which came into effect in May 2018. Under the said regulation, data users generally must report breaches of personal data within 72 hours of notice of the breach. Indeed, many jurisdictions other than the European Union, like Canada, Australia, have similar rules. The risk of data breaches have grown immensely since GDPR was introduced in 2018. For example, Yahoo UK arm was fined £250,000 over a data breach affecting more than 500 million users. Facebook was fined £500,000 regarding the Cambridge Analytica scandal. The Information Commissioner's Office in UK announced its intention to issue a fine of around £183.4 million to the British Airways and a sum of around £99 million to Marriott International. The Hong Kong government is formally reviewing and studying possible amendments to the ordinance jointly with the Office of the Privacy Commissioner, aimed at strengthening the protection of personal data in Hong Kong. In late January this year, the Constitutional and Mainland Affairs Bureau published a paper for discussion at the Legislative Council panel meeting. We note that among the 6 proposed amendments to the ordinance, the introduction of mandatory data breach notification mechanism is included, so that the Privacy Commissioner could monitor the handling of data breaches by organizations concerned. The Bureau considers the following matters should be taken into account when establishing the said mechanism. It could mean a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored, or otherwise processed. The Bureau finds that a data breach having a real risk of significant harm should be reported by the data user to the Privacy Commissioner and impact individuals. The data user should notify the Privacy Commissioner within a specified time frame once they become aware of the data breach. The Bureau believes as soon as practicable and under all circumstances in not more than 5 business days is reasonable. The Bureau is considering to allow data user to make written notification to the Privacy Commissioner by way of email, fax, or post. Possible information to be specified in the notification include a description of the data security incident, the cause of the data breach, the type and amount of personal data involved, an assessment of the risk of harm, the remedial action taken by the data user to mitigate the risk of harm, and the action that the data subjects should take to protect themselves against the risk of harm. It is not specified in the legal consultation paper. That said, we suspect the Hong Kong government may consider directly impose administrative fines on data users for failing to notify data breach incident on time. The set fine may link to the annual turnover of the data user, which is similar to the current rules under the GDPR.